are starting our working week. We have very busy and interesting program. You can see our schedule on our website and on Facebook page. We're starting our first press briefing. We'll be talking to the experts of Reanimation Package of Reforms. They will present edits to coalition agreement. They distributed them to all the participants, but then they found out that not all of them were introduced into the text of the coalition agreement because the experts believe that without such amendments, the package of reforms will not really bring the reforms that the society needs. We'll be talking to Yuri Hanushchak, Director of the Institute for Community Development, Yulia Kirichenko, expert of the Center for Political and Legal Reforms, Nataliya Shulga, Director of the Ukrainian Scientific Club, Viktor Butoka, Head Expert of the Group on Energy Sector, Igor Shumylo, KSE President Advisor, and he's responsible in the RPR for banking sector, and Alexander Pavlichenko, the expert on reforms in the human rights sector. You're welcome. Good afternoon. I will probably be the first one to start, because the main thing we are lacking, even though they promised that it will be included, is the regulations for the work of the coalition. What was in the first text, what was quite well presented, especially taking into account that that was the first time it was presented, and we have this document which is called coalition agreement, and we want it to be agreement, because without that provision it's just a declaration on intentions. What is introduced into the regulations of the work of the coalition is a very important thing for the work of coalition. Coalition takes responsibility to vote for the drafts which are submitted by the government. The government takes a responsibility to resign if this does not happen, and part of that regulations which are not part of coalition agreement yet, that is what should become part of the constitution. That is what should balance the system within the triangle. Verkhovna Rada, Cabinet of Ministers, President. What else do we need to pay attention to? When it comes to anti-corruption reform, two items are now missing. The first one is state funding of political parties, and the second item is ensuring execution of the provisions of the legislation on publishing information about the final beneficiaries and owners and controllers of legal entities. Without that, the anti-corruption part doesn't mean anything. And small mistake, which is about single social contribution. It states that it should be 18%, but it does not say that the pensioners will get adequate pension. But in the part which is about social protection, it says that it will lead to bringing pensions to adequate level. So this should be made similar. Then the election process. There are some amendments which are to be introduced, because now the one who buys all the time on broadcast wins, and it's competition of money but not competition of ideas. And if we have different system of elections, we should have the different forms of organization of self-governance, direct elections of city had is contrary to proportional system of elections. In the proportional system of elections, we need to state that this part of self-governance is elected according to party lists, and the head is elected differently. And if it is single mandate elections, then it could be about the direct elections of the mayor. So this is it. Good afternoon, Yulia Kirichenko, manager of Reanimation Package of Reforms, Constitutional Reform. As to constitutional reform, we welcome politicians that this reform, this section is now in coalition agreement, because in the beginning there were drafts which did not have anything on constitution reform. We do hope that the new parliament, newly elected president, will be able to implement political reforms, and these are constitution reform and election legislation. I would like to remind that one of the objectives why people went to the Maidan was conducting political reform, reforming the mechanism of authorities. And we want new politicians to remember that the people did not want to bring just new faces to power. We want political reforms. What do we see in coalition agreement? Unfortunately, we do not see a single word on the content of reforms. There's a section which does not provide any answer about even the direction of the constitutional reform. Are we moving towards presidential republic, or where? The politicians today cannot even agree on in which direction we are moving. And we are calling for, before the agreement is signed, the main directions of constitutional changes are to be registered. Also, we see the position in coalition agreement that will be amending constitution as needed for implementation of reforms. That is unacceptable attitude to constitution. That means what we will not, what will be hampering us in constitution, we will change. We cannot do that. We will change. The politicians are to work within the constitution. The constitution should become the agreement between the politicians and the society. So we request to change the attitude of politicians to constitution. Please put down that we are conducting comprehensive constitutional reform based on the vision of all the reforms, and then in accordance with the agreement, in accordance with the framework of the reform, we'll be reforming the state. We're also calling upon politicians. It's not in the coalition agreement to implement constitutional changes only in Section 13 of the Constitution of Ukraine, according to Section 13 of the Constitution of Ukraine, because we believe that when the procedures were violated in 2010 and in 2014, that was also the change of our main law. And also, we still have the law on national referendum named after Yanukovych, which sets the order of amending constitution, of holding manipulative referendum. The politicians are not writing that they will establish the democratic procedure of holding referendum. We know how referendum could be used. We see the Crimea and Donbass, and that is not in the coalition agreement. I call upon you, don't use this temptation which is left in our legislation. Nataliya Shulga. Nataliya Shulga, I represent the Ukrainian Scientific Club, and I am the main expert in the group science and RPR. the science and education have never been in the priorities of the state, and we see the consequences in economics and humanitarian sector everywhere. So in the first version of coalition agreement, there was no mention of science. We managed to draw attention to the fact that the reform in scientific sector should be finalized, and that includes both science and education. The law on higher education has been voted for and ratified. We need to make one more step to finalize the reform in scientific sphere, to pass a new law on scientific research activity and new law on national fund of research, which, according to which there will be funding of R&D. And within that fund, there will be the sections which will finance the fundamental research. They will support innovation programs and startups within the format of the state programs of the development of the country. Again, I would like to emphasize that without the first-class education and science, we cannot create innovative economy. And for 9 years, we've been trying to explain that to the leadership of the country. And until the leader of the country believes that science and education are priorities for the state, we will have no future. We want to explain that to our leaders, convince them that unless we have in the coalition agreement the commitment to finalize this reform, to give impetus to the development of research and education, we'll have no future. And all other addenda show how non-priority this sector is. Thank you.
Victor Butok now. Victor Butok, I'm an RPR expert, the Group for Energy and Energy Resources. I can't complain that our suggestions and proposals were not included into the coalition agreement. If you look at the very first version of this chapter and what we got later, the changes are rather significant. However, we have more serious objections. And the first and the main, our energy resource and our huge reserve, is energy efficiency. So we suggested that this chapter should be structured around the energy efficiency issue. The people do not understand, and the participants, and if you have seen the structure of this chapter, you know, it first pays attention to the interests of huge stakeholders, and then, only then, we find energy efficiency. Praise God, it is there at all. There is still no understanding that these markets have to undergo restructuring, and the delineation of the kinds of activity of traditional stakeholders, and also the introduction onto the market new participants, new players who work with renewable energy sources, and we shall create the most favorable climate for these stakeholders, because the world is entering the energy deficiency situation where the traditional fuels are concerned and the traditional sources of energy become unbelievably expensive. This all leads us to the third issue, and almost no one among stakeholders and participants in the process have not understood this. We said, let's work out a very new, absolutely new strategy, and then we'll join to it the events and measures. But the answers were, why do we need it? We already have it. People have difficulties in understanding that clear-cut benchmarks and yardsticks for the long-time perspective are very needed, because we need to give clear signals to customers and to players on the market, how our energy system is going to look. Besides, all technological solutions on the technical market are realized and then exploited for a very, very long time, for decades. So if we do not begin to put down the new understanding today and the new structure, we will reap whatever we sow today. We do not have time to come to new models. Igor Shumylo. Hello. What I'm going to talk about was in all the previous speeches and maybe in other ones. First, it is the strengthening of openness, transparency and accountability of the bodies. In this case, the National Bank and other regulators of the financial market. And on this basis, and only on this basis, the strengthening of their political, financial and operational independence, which requires respective amendments to the law on the national banks and other regulators of the financial bank, and the appearance of an entire range of documents, including joint documents with the Cabinet of Ministers, including the strategy of development of the financial market, of the National Bank itself, for medium-term and long-term perspective, and also the working out of documents like they have in the European Central Bank and other documents that reveal the essence and details of monetary policy. On the other hand, this is the adoption of a range of legislative acts that would allow to improve the procedure of bankruptcy and restructuring of the banks, and on this basis, a significant improvement of the health of the assets and the possibilities to give loans to economy. The public awaits the adoption of legislation on restructuring of mortgages on the basis of foreign currency and also on the settlement of disputes linked to the law on bankruptcy. Very soon we hear the words, we need a law, but however, when we mention different laws, for instance, the law on currency regulation, we do not describe what actually we want and need. I think this is very, very important to describe the principles along which the amendments to the laws should be introduced or new versions of the laws should be adopted. And this especially pertains to the law on currency regulation, without which you cannot improve the activity of the National Bank and also derivatives. Mr. Alexander Pavlichenko, good afternoon, good morning. The most significant and essential in the document that we are talking about today is that there was no human rights component in this document when we talked about the coalition agreement. We recognized our coalition of human rights organizations that the basic principles on which we build the observance of human rights were absent. First of all, the principle of the rule of law that has to permit all the components of the coalition agreement, so the principles of the rule of law, observance of human rights and pluralistic democracy should be a cornerstone on which the Ukraine's joining of the Council of Europe was built, and other European institutions. And we talk about specific blocks and chapters where the human rights component is absent. Even in the methodology of the coalition agreements, we do not find them. This is a technical document which provides mostly for technical coordination during governance and the direction of the movement in the direction of human rights is absent, and the state still dominates a person. And of course, we shall speak here of the reform of the court system and the law enforcement bodies. It should be headed by the issues of human rights. On our side, well, we were approached with a proposal to submit our proposals. We submitted general answers that required conceptual reworking of the coalition agreement. This was impossible to do within such a short period, a brief period of time, so this is still a problem that requires solution. Thank you. Colleagues, I have a first question. I'd like to talk to Yuri Hanushchak. Do the experts of the Reanimation Package of Reforms have the understanding of interaction with the President and the Cabinet of Ministers and the Parliament? Under which conditions the President can, the Cabinet of Ministers can resign? You know, in the chapter which has to be there but is not there, there is a model. First of all the draft laws are filed by the government or a authorized person from the MPs, and there is also a mention of the President, which is actually surprising because in the parliamentary presidential republic he is not a subject of a legislative process. We think that this is a mistake, but we can, of course, accept this because of the traditions that we have. If the parliament does not vote in favor of those draft laws, then, of course, the Cabinet of Ministers can apply for resignation, but there is a danger that the parliament will distort the laws up to this state of where they are not recognized. In this case, the parliament is guilty, so the constitution has to carry additional clauses, and the president has to have a choice either to dismiss the government or to disband the parliament. If the parliament does not agree with what the government proposes, then the president has to react very decisively. It is evident that in this case the rights of the president will be lowered, and the president has to forget where the Cabinet of Ministers is. And all the departments that are being organized have to create a consultative, have to have consultative and administrative bodies, not when the departments of the presidential administration replace some departments of the government. In the triangle of relations, we should take the traditions of parliamentary presidential republics, for instance, like in Poland. I don't know who will answer my question, but, well, you can correct me, but the coalition agreement itself is a document, you know, it's more like a memorandum of intentions. But what is going to happen if some political forces during the process will see that their concept on some points has changed? So what is going to happen then? What can be a stick or a carrot for such political forces? Because we have an impression now that we lose a lot of time on some details, and then, as Mr. Hanushchak said, everything can be distorted. So what is the stick for political forces? By the way, this was in the chapter that was omitted. there were obligations and duties of this coalition. In the case that the coalition is disbanded, then it led to unequivocal resignation of the cabinet of ministers, although I would like the constitution to have the option of the disbandment of the parliament. In another case, a group or a faction can join the coalition, because a group is something composed of territorial constituencies, MPs. So these things should be added to the procedure of the work of coalition, and they should be strict for both sides. And the sides here are the majority and the government that works on the basis of this coalition agreement. I hope that this will be introduced. I think that the very important issue, we sometimes confuse the notions, and the fact that we've been working on the coalition agreement for such a long time again reminds us that the parties came to elections without no programs. For instance, the government that says that they are the government of reforms actually worked without any program. If the Prime Minister says that we only have to put down that we will work to implement the association agreement, it doesn't require any words to explain. Of course, the alliance of political forces with different positions can be. You probably remember that Poroshenko reminded us of Merkel's words, who said that a clear-cut agreement should be is a way to success. And of course, the government should have their program. So we have to at last come to clear-cut aims and programs and of the coalition agreement. The law is being submitted if the principles are agreed, and probably we should have a discussion on what the principles are that lay down foundations for such code or a law, and then it can be changed. Or this is a diversion from the principles. We don't have, unfortunately, time for questions because we have our next speaker, and our next press briefing is going to happen in a minute.